Do stepchildren inherit if there is no will? Have you ever wondered what happens to stepchildren when a step-parent passes away without a will? This is an important question, especially for blended families and those in second marriages. Understanding the inheritance rights of stepchildren can help avoid confusion and ensure that everyone is treated fairly. In most cases, stepchildren do not automatically inherit from their stepparents if there is no will. This is because intestate succession laws typically prioritize biological relatives over step-relatives. So, unless a stepchild has been legally adopted, they usually do not have inheritance rights. Intestate succession refers to the legal process that determines how a person's property is distributed when they die without a will. Each state has its own laws about who inherits, but generally, spouses and biological children are at the top of the list. Stepchildren are not included unless they have been adopted. If a stepparent legally adopts their stepchildren, those children gain the same inheritance rights as biological children. This means they can inherit from the adoptive parent just like any other child. However, without that legal adoption, stepchildren are left out of the inheritance picture when no will exists. In some rare situations, specific laws in certain jurisdictions may allow stepchildren to inherit if there are no biological heirs. However, these scenarios are uncommon and depend on the state's laws. For blended families, it is essential to consider estate planning strategies to ensure that stepchildren are included in the distribution of assets. Creating a will is one of the best ways to specify who inherits your property. A will allows you to clearly state your wishes, including provisions for stepchildren. Another option is to set up trusts. Trusts can be a great way to ensure that stepchildren receive a portion of your estate. They provide a structured way to manage and distribute assets according to your wishes. If it is feasible, legally adopting stepchildren can also provide them with automatic inheritance rights. This can be a meaningful step for families looking to solidify their bonds and ensure that everyone is treated equally. In blended families, careful estate planning is vital to prevent unintended consequences. For example, if a spouse inherits the entire estate and then passes away without a will, stepchildren may still not inherit unless they were adopted or included in the estate plan. To sum it up, stepchildren generally do not inherit from stepparents without a will unless they have been legally adopted. However, through thoughtful estate planning, it is possible to include stepchildren in the distribution of assets. Taking these steps can help ensure that all family members are treated fairly and according to the wishes of the deceased.